Hi, my name is NATASYA binti SAIFUL EDRIS, metric number 2744069. So me and my colleague will discuss on the issue of fake news according to the Malaysian law. Let's proceed on the introduction. So fake news. Fake news often led to the exchanging of information. Facebook and Twitter are an example due to the rise of social media platform. The rise of fringe politics has encouraged xenophobia and hate speech everywhere around the globe, Malaysia included. On 11 April 2018, Anti-Fake News Act was introduced. One of the former ministers said that the bill was introduced with a purpose to prevent on the issue of dissemination of fake news, not freedom of speech. However, it has a mixed reaction from the public and the media in the matter of affecting the freedom of speech in Malaysia. It potentially to have a significant impact in educating human rights, as it is important to the public to understand the significance of human rights declaration. It is also said to be vague and overly broad. So how to address the circulation of fake news without undermining the freedom of expression and democracy process? So freedom of speech is a basic right that enables people to seek, receive, and impart ideas, have important conversation, and hold those in power accountable. Freedom of the press is a basic element of freedom of expression. It is no less relevant in times of global crisis, especially facing the COVID-19 pandemic. Misinformation and disinformation are terms used to describe the dissemination of false information. Both terms refer to the inadvertent sharing of material without the intent to mislead or harm. There have also been cases where individuals make false claims about the outbreak. For instance, some individuals claimed that military personnel were allowed to assault civilians. The public has a right to know and access various information sources such as government reports and
Good
opinions.
day, my name is NAJWA binti ZAINI, metric number 273390. On my part, I'm going to present about the fake news law of multimedia communication in Malaysia. So before the Anti-Fake News Act 2018 being repealed, Section 4 of this act has prescribed the offence of creating, offering, and publishing fake news or publication that containing fake news. But after this act has been repealed, there are few other laws that can still be referred regarding the dissemination of fake news. For example, the law that governs the journalists and media, which is the Code of Ethics and the Canon of Journalism. The Code of Ethics was prepared by the Institute of Journalists Malaysia (IJM) after being suggested in 1947 Hutchins Commission. Moreover, the COJ also has been established since 20 May 1918, relating to the 5 principles of Rukun Negara. We also have the guidelines made by the Malaysian Communication Multimedia Content Forum to be followed by the internet service provider to make this law to ensure that the unreliable resources and false content are not being circulated by the media. We also have the Printing Presses and Publication Act 1984 that control all the restrictions on the production and posting of the printing media. It's one of the example of cases of fake news is the SITI team media senior against Saravanan. So in this case, the plaintiff accused that the defendant has made a defamatory act against him on his forum, which is as a chairman of MIC. However, the defendant argued that he was not made any defamatory statement, but it's actually as a comment against a plaintiff, and he counterclaimed to that defendant is making a fake news and against the Federal Treasury of MIC and make profit from it. So the court held that he has stepped at the defense of the defendant because the defendant has justified his action. However, the counterclaim made against the plaintiff was rejected because the fake news cannot be accepted if the defendant did not submit the exact language, which is in Tamil. The court specified that the defendant are not allowed to state the impression of the content, but must be the exact whole contents of the substance. We can see from this case that it's important to ensure the accuracy of the news received, because as soon as it has been published and circulated to the public, it will not just create fear and false alarm to the public, but also affect the reputation of any person, especially when the statement is fake and defamatory to the person.
My name is AFIFAH binti AHMAD NIZA and my metric number is 273053. I'll be discussing about removal of publication containing fake news. It seems that Printing Presses and Publication Act 1984 only provide temporary removal such as stated in Section 8B, which is about suspension of publication maximum 6 months, and Section 8.6, which is about suppression of publication during the appeal. If the accused fails to remove, he will be liable for maximum 2 years of imprisonment or maximum fine 10,000 ringgit. It seems that Communications and Multimedia Act 1998 also provide temporary removal, where the Act provide power to Malaysian Communications and Multimedia Act (MCMC) to conduct inquiry either public under Section 58 subsection 2 or private under Section 61, which allow MCMC to pursue the licensees to block the user who spread the publication containing fake news by issuing direction if they violate the conditions under Section 51 subsection 1 and by enabling their required application services under Section 193 subsection 2B and Section 194 of CMA. However, it seems that MCMC doesn't have the power to prosecute the offender who published the fake news, as the offence should be directly handled by the judiciary and not the executive body. Lastly, it should be noted that the Anti-Fake News Act 2018 provides comprehensive guidelines for the order to remove publication containing fake news. In this act, the victim can apply ex parte to the court against the accused to declare that the publication containing fake news under Section 7, subsection 1, and then the court will grant the order to remove such publication under Section 7, subsection 3. If the accused fails to comply, he will be liable for a maximum fine 100,000 ringgit under Section 7, subsection 6. Then the court may make an order to direct a police officer or an authorized officer under CMA to remove the fake news publication under Section 9, subsection 1. Even though party may apply an ex parte may be applied to the victim, to the accused, to the court order, the accused may also apply to the court to set aside such order under Section 8, subsection 1. However, no set aside can be granted if publication containing fake news is prejudicial or will cause prejudicial to the public order or national security. Therefore, it can be seen that all of these statutes provide ways to remove publication containing fake news, as publication containing fake news can cause severe conflicts and problems in the future to the people.
Hi, now I'll be explaining about other laws regarding fake news besides the Anti-Fake News Act 2018. So we have Penal Code, Printing Presses and Publication Act 1984, Sedition Act 1948, Communication and Multimedia Act 1998, and also Emergency Essential Powers No. 2, Ordinance 2021, the Ordinance. So now for the first one, we have Section 505 of Penal Code, where it provides that any person who makes, publishes or spreads any statement, rumor or report with the intention to cause fear or panic to the public commit an offence. He can be punished with imprisonment up to 2 years or fined or both. So you can see in the case of Leong Mun Kwai against PP, where the accused was charged under Section 505 subsection C of Penal Code on the grounds that he published a statement which clearly indicated to incite people to violence in a political rally against the ministers and members of the parliament. Next, Printing Presses and Publication Act 1984, we have Section 8A subsection 1. It is an offence to publish false news in which such publication is published with malicious intent. So the person responsible behind it is punished for imprisonment up to 3 years or fine not exceeding 20,000 ringgit or both. You can see in the case of Lim Guan Eng against PP, where the appellant was convicted under this section because he published malicious fake news in the pamphlet called Mangsa Dipenjarakan. Besides that, the Sedition Act 1948 in Section 4 subsection 1 provides that any person who does any act which has seditious tendency or says any seditious words is guilty of an offence and liable to a fine not exceeding 5,000 or imprisonment up to 3 years or both. So you can see the definition of seditious tendency in Section 3 subsection 1 of the Sedition Act, where it says that it is a tendency that brings hatred or dissatisfaction to the government or ruler, or to promote ill feelings among the different races in Malaysia. So you can see the case of PP against Ui Kisaik, where one of the accused was charged under Section 4, subsection 1B of the Act for uttering seditious words, while the second and third accused were charged in subsection 1C of the Act for printing the seditious words. So next, we have Communication and Multimedia Act, where in Section 233 provides that a person who creates or initiates false, indecent or offensive comments by means of any network application or service commits an offence if he has intention to harass another person. So with the emergence of internet, it is very essential to have laws pertaining to this matter, Twitter. So in section 211 also classifies a false content as offensive, which is prohibited under the law. So in early March 2020, when Tan Sri Muhyiddin was nominated for Prime Minister, he received backlash from the citizens, and there was a human activist. She urged her followers on Twitter to protest, and as a result from this, she was investigated under Section 4, Subsection 1 of the Sedition Act, and also Section 233 of the Communication and Multimedia Act for the offence of improper use of her social media account. Last but not least, we have Emergency Ordinance 2021, which was enforced in conjunction with the proclamation of emergency that was declared by the government to combat the outbreak of COVID-19. So specifically, any creation, publication, or transmission of fake news, as well as the failure to remove publication that contain fake news information in it. So it is an offence under this emergency ordinance to spread fake news pertaining to COVID-19 or emergency proclamation that is false, whether in the form of visuals, recordings, and whatsoever. So he is punishable with a fine not more than 100,000 ringgit or jail not more than 3 years or both. So for instance, A claims that B died due to the COVID-19 vaccine, so he can be charged under this emergency ordinance 2021. So I think that's all from me. Thank you.
Hello, my name is FATIHAH binti FAZILAH, and today I will discuss the issues regarding the Constitutionality and Repeal of Anti-Fake News 2018. So this act was introduced by Datuk Seri Muhammad Najib bin Abdul Razak a few weeks before the general election with an intention to deal with fake news. This law has received a lot of issues, such as criticism from the human rights organization, which is Article 19. This organization believed that this act was against the freedom of speech and expression for the citizens in Malaysia. They said that the government has used this tool as a powerful tool to regulate the journalism, online discussion, and also debate. And they said that the government was too rushed to enact this law without seeking a proper oversight from the respective committees such as Parliamentary Select Committee and also the media actors. Therefore, they urged for the government to repeal this act entirely. So, okay. So the next issues is so when the new government has won the general election. So the new government was led by Dr. Mahathir bin Mohamad. They have an intention to repeal this Act of Anti-Fake News Act 2018. However, this intention has been rejected by Dewan Negara. However, Dewan Rakyat has voted in favor of the repeal bill of Anti-Fake News Act 2018. Okay, so one of the reasons why Dewan Negara opposed to this bill because mostly Dewan Negara is controlled by the supporters of the previous government. So therefore it's a bit too hard for them to accept this bill. However, in 2019, finally, the new government has successfully repealed the Act of Anti-Fake News Act 2018.
I am DEEVAGARAN NAIDU, and I am here to present on the analysis of opinions on the issue pertaining to anti-fake news law and also to conclude the presentation as a whole. So firstly, we must look at why do we actually need an anti-fake news law. There are three reasons to this. Firstly, it is to prevent the spread of misinformation. The spread of false facts and information may deter any effort to combat against any issue that might be harmful to the society. Secondly, it is also to prevent scamming, whereby vulnerable social media users such as the elders might be scammed and hoaxed by scammers. And lastly, it is also to maintain the peace of the society generally, whereby an anti-fake news law may prevent any dissemination of propaganda that can cause chaos and confusion to the society. However, there are several challenges in implementing the anti-fake news law. Firstly, interpretation of the law itself, whereby there is a huge possibility of the anti-fake news law being interpreted widely and arbitrarily to accommodate political motives. Secondly, it might be also impeding the freedom of speech, whereby the implementation of anti-fake news law may curtail the freedom of speech as provided in the federal constitution. Lastly, it might be a huge challenge to the press freedom itself, whereby there are many genuine concerns by the press and also critics on the freedom of news reporting in the future after the implementation of this anti-fake news law. There are several suggestions that we can make to ensure that the anti-fake news law is efficient in combating against fake news. Firstly, in terms of neutrality, enforcement agencies must be bipartisan and neutral in enforcing the law and not abuse their authority by targeting specific groups. And secondly, we must have better algorithms, as in the social media platforms must have better technology and system to filter out fake news and expose people who spread misinformation through social media platforms. Next, we must also spread more awareness in which the government must educate the citizens extensively on the implications of spreading fake news. And lastly, we must have better alternatives to combat against fake news other than relying on the law itself, whereby we can enforce and apply platforms to fact check news to ensure the validity of the information. An example of this is the website known as sebenarnya.my, whereby citizens can check the validity and authenticity of the news itself. Thank you.